Good morning and welcome to the docket. I am your host, Bob Mata, and this is our continuing coverage of the people of the state of Wisconsin versus Stephen Avery, a full case analysis, guilty or innocent, or the alternative title,
Did he do it?
Did he do it? Did he do it? So as you can hear, I am joined by my beautiful and brilliant co-host, Allie. What's up, girl?
Hey, babe. Hey, y'all.
So we have 11 episodes of Avery in the books. We took a break I had to do other things, namely Murder on Songbird Road. That took precedent over Avery because it was a timely issue. So we are getting back at Avery. We're going to get back to digging in deeply into the case. Today, we had a major event in the case, which is the Appellate Court has rendered its opinion on Stephen Avery's most recent appeal based on the denial of his request for an evidentiary hearing at the trial court level. So they appealed that, and we are going to go through that. And I just want to say, no matter what the appellate court decides, that does not change the fact that you and I, Bob and Allie, need to figure out whether or not Stephen Avery is guilty or innocent, or
Did he do it?
did he do it? So that, like, whatever goes on with this is not going to stop our analysis, because you know what? Sometimes we disagree with the appellate court. Sometimes we agree with them, but we got through, I think, maybe 8 to 10 pages of this. And it's a little befuddling. So I think, and I want to swap between us reading it. Maybe you're not feeling that. All right, that's
Well,
fair.
this is a podcast, so I'm trying to keep it clean. And now you've created something to be blooped out by Darren.
I think people like when we have our kind of like normal discussions. I don't think that has to be blooped out. What do you guys think? All right,
Well,
so I'm going to enable scrolling. I'm going to pull it up. I think that there's no reason to.
talk about what you're doing while you're doing it.
I think we do that all the time, honey, in the podcast. Honey,
No, we don't.
Yes, you're like, oh, I want to pull it up. I have it right here.
That's on a live.
No, that's actually, if you go back to our Avery episodes, I'm like, oh, do you have something? You're like, yeah, I've got something here. Let me pull it up real quick. I don't think there's anything weird about that. Okay. But Darren, you can cut all this out. Okay, so I'm gonna blow this up. So let's dig into this Court of Appeals decision, which is dated and filed January 15th, 2025. This came out to the public at 8:30 a.m. this morning. It is appeal number 2023 AP 1556, and it is the state of Wisconsin as the plaintiff versus Stephen A. Avery, defendant appellant. So this is a appeal from an order of the Circuit Court for Manitowoc County, and Angela Sutkowitz was the judge down there. And this is before Neubauer, Grogan, and Lazar or Laser. And those are the three justices that at the appellate court level that rendered this opinion. So per curiam, opinions may not be cited in any court of the state as precedent or authority, except for the limited purposes specified in Wisconsin statute rule 809.23. What does that mean, babe?
I don't know, but Darren can cut that as well. But what it does mean is that it's that opinions.
Wait, why does Darren need to cut that?
Well, I mean, I guess not. All right. So it just means that it can't be cited for precedent or authority, meaning in another case that the rulings and opinion of the court here are not to be cited by lawyers or relied on. You know, whenever they do that, it's creates this whole side area of the law that doesn't exist.
Right. So, per curiam, Stephen A. Avery appeals a circuit court order denying his Wisconsin statute 974.06 motion without a hearing on the basis that his motion was insufficiently pled. On appeal, Avery argues his motion was sufficiently pled to warrant an evidentiary hearing. We disagree and affirm the circuit court's order. Now, if that language is a little confusing to you guys out there because you don't practice law, they have denied Avery's motion. So the language is very wordy. Basically, they're saying, sorry, denied, big stamp. Here you go. You're done.
Yeah, so what happens is when you file a post-conviction petition, it kind of goes in phases. And if they deem your petition insufficient, you don't even get an evidentiary hearing. They just rule on the pleadings that this is not enough. And that is what happened here. And that is what was appealed by Stephen Avery, asking the higher court to say that the lower court should have at least held an evidentiary hearing. And as we get through this opinion, we'll hear the court's reasoning on why they decided that it wasn't even worth holding an evidentiary hearing, that they didn't even reach the burden that would warrant a hearing.
Okay, let's go through the background. So what they do next is that the appellate court is going to give you the procedural background, which will explain to you as we kind of go. Hold on, I got a cough.
So the court's going to give both the procedural and factual background first, and they're not going to include all of the facts, and it's going to be tailored to their reasoning and their logic.
Okay, so this is the third time Avery is before this court on appeal. We have previously summarized the facts of this case in Stephen v. Avery, or State v. Avery, 2011 Wisconsin App 124, and State v. Avery, which is Avery 2, with the case number 2017 AP 2288-CR. So for context, and here they're going to give some background on the case in the event that you don't know anything about the Stephen Avery case, which is, this case was the basis of the very popular Netflix series Making a Murderer. And then some years later, kind of an opposition piece was put out convicting a murderer, I think it was called. But so this is one of those cases that obviously has sparked a lot of interest because of primarily the Netflix series. And obviously, this is one of those cases that has two very decided and divided sides where people are just adamant on both sides as to what they think did or did not happen. So, for context, on October 31 of 2005, Avery arranged for Teresa Hallbach, a 25-year-old professional photographer, to photograph a vehicle at Avery's Auto Salvage. Now, I'm not going to read the sites. So at the time, Avery's Auto Salvage was located on a 40-acre piece of property owned by Avery's parents, Alan and Dolores. Avery, along with his brother Charles, lived on the property and worked at the salvage yard business. Another brother, Earl, worked at the salvage yard, but did not live on the property. Avery's sister, Barb Janda, lived in a trailer on the property with three of her sons, Bobby, Blaine, and Brendan. And again, if you know anything about the case, you know that Brendan was ultimately convicted as being a participant in the homicide of Teresa Hallbach. As relevant, Bobby Dassey, then 19 years old, reported that on October 31st, 2005, he was looking out a window from his family's trailer and saw Hallbach arrive at approximately 2:30 p.m., taking photographs of a vehicle and walked towards Avery's trailer. Bobby then stepped away from the window. He never saw Hallbach again. On November 3, Halbach's mother reported her missing. On November 5, volunteer searchers found Halbach's RAV4 in the Avery salvage yard. Quote, the vehicle was covered with branches, plywood, and the hood of another vehicle, end quote. So after finding the RAV4, sorry, hold on. After finding the RAV4, police searched the Avery property and over the course of the next 4 months, discovered and identified evidence including burned bone fragments in and around a burn pit with DNA matching Halbach's, both Avery's and Halbach's blood in the RAV4, the remnants of electronic devices and a camera, the same model as Halbach's in a burn barrel, Halbach's RAV4 key in Avery's bedroom, with Avery's DNA on it, Avery's DNA on the hood latch of the RAV4, deposited, the state later claimed, by Avery's sweaty hands, and a bullet and bullet fragments in the Avery garage containing Halbach's DNA. So the state charged Avery in part with first-degree intentional homicide as a party to a crime and felon in possession of a firearm. The case proceeded to a 5-week jury trial, during which Avery's defense was that law enforcement was biased against him and planted the evidence to implicate him, which the quote real killer, end quote, exploited to also plant evidence on the property. The jury found Avery guilty. In 2009, Avery moved for a new trial, in part based on the circuit court's erroneous exclusion of Avery's third-party perpetrator evidence during trial. Avery wanted to implicate several alternative perpetrators in Halbach's murder, including, as relevant for the present appeal, Bobby. The circuit court denied the motion. Avery appealed, and we affirmed. We determined, quote, the third-party liability evidence proffered by Avery identified a large group of individuals who he claimed were near the Avery property on the date of Halbach's murder, but who he acknowledged had no motive to harm her. This evidence failed to satisfy the quote legitimate tendency test under State v. Denny and was properly deemed inadmissible. So what do you think of that, babe? And we're going to get into Denny a bit because we're going to talk about it. What's your first reaction to that?
Well, I actually want to react to the sentence before. You can see how the court kind of lays out the facts when it's like, well, at their trial, they said that the state was setting up Avery, and that the real killer exploited that setup, where I'd say that they were arguing that in the reverse, that the real killer, you know, left the car there, or I don't know. You can just tell by the way that they write it that they are
Poo-pooing the concept.
I was trying to come up with a word better than poo-pooing. That was literally, I'm sitting here saying, but exactly. And that just read that sentence again.
In 2009, Avery moved for a new trial, in part based on the circuit court's erroneous exclusion of Avery's third-party perpetrator evidence during the trial. Avery wanted to implicate
Wait,
several.
sorry, babe. It's the sentence before it. I'll read it. I'll
Okay.
say it again. Sorry, Darren. So the sentence that I'm referring to is how they say that the case proceeded to a 5-week jury trial, during which Avery's defense was that law enforcement was biased against him and planted the evidence to implicate him, which the quote real killer exploited to also plant evidence on the property. So that wording, it's very dismissive and like underhandedly mocking the defense.
Yeah, well, I mean, the fact that they put in quotes the real killer is exactly what your point is. I mean, that's like when you air quote something, you guys know what the connotation of that is, and that's what they're saying. Like, oh yeah, the real killer, sure, pal. You know,
Well, and also the concept that somehow the real killer would know that the state was planting evidence and then exploit the fact that the state planted evidence. It's
I agree. It's very dismissive, like early on. So, and what Allison's point is for lay people is that many times in appellate opinions, you can get the court's vibe very early on based on their tone and tenor in terms of how they're writing. Because remember, there's three judges that heard the appeal, but one of them drafted it. So that doesn't mean that the other two didn't look at it, and their clerks may have helped and things of that nature. But it really does early on in an opinion give you an idea of just how close or how far away they may have been to convincing the appellate court to grant him the evidentiary hearing. And based on what Allison just pointed out, I would say that they're a million miles away. So in uh in 2017, Avery filed another section 974.06 motion raising new claims, which is hereinafter referred to as Avery 2. The circuit court denied the motion, and Avery filed motions to vacate and for reconsideration, as well as 2 supplemental post-conviction motions. Now, Allison, this process, the post-conviction process, I think can be very, very confusing for people that don't practice law. Shit, it's confusing to me because I'm a trial lawyer, not an appellate lawyer. So can you explain just briefly what the difference is between a direct appeal, a post-conviction relief act petition, when those are appropriate to file? Just kind of give us a little bit of an understanding of what those things are.
So generally, and it may change state to state as I'm seeing in Indiana, but you have what's called your direct appeal. And that is the first appeal after your conviction in a criminal case. So, in that situation, you can only cite to the record. You can't bring in new evidence. You can't make arguments that someone um, didn't do something they should have for X, Y, and Z reason, unless somehow it's stated on the record, for example, that a lot of lawyer complaints or ineffective assistance to counsel have to wait until direct appeal because their logic is not on the record. While other things are so clear, like the lawyer didn't do something blatantly evident on the record itself, that you would include it in the appeal. After you go through what's called the direct appeal process, and again, it's limited to the record. You don't make any new arguments. You don't talk about evidence that didn't get in. You take that to the Supreme Court, and then you have the option to take that to the federal court, and post-conviction comes in afterwards. It's sort of like your last ditch effort, and there's layers of post-conviction relief. The first post-conviction petition is where if you've got any chance at post-conviction relief, you're going to get it because there's not as many procedural roadblocks, that they are waived, that it's not significant enough to raise, things of that nature. Once you get to your second post-conviction petition, you're based on newly discovered evidence, and that newly discovered evidence has to be sufficient enough to be overwhelming to warrant the court to even consider it. And that's sort of where they got stuck here, in the sense that the lower court did not even grant the defense a hearing. They're saying on your pleadings alone, they are insufficient under post-conviction law to grant you any relief whatsoever. And Bob, let me know if I need to expound on that a little bit more.
No, I think that was pretty clear. And I think that there was some hope because a new judge had been assigned at the trial court level, but they ended up getting the same results. Because this is, I guess, one thing that I'd want you to elaborate a little bit on is are you barred, or is there a limit in which or to how many post-conviction relief act petitions that you can file?
So the first post-conviction relief act is the almighty. And again, that's just because the burden is different, the procedural bars are different. So that's where you're going to have the most opportunity. But after that, you can file as many as you want. but you've got to reach a much higher burden. And again, a lot of that is going to be the most evident, or what occurs most often, is newly discovered evidence. And that newly discovered evidence can't just be like, hey, there was this thing available before. No, 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 no. You've got to show you couldn't have found it before with all the due diligence that if you did everything that you should have, this piece of evidence you could not have found. You didn't know the person existed to even look for them, type of situation. But over and above that, it has to be compelling enough to warrant relief. And here, the newly discovered evidence spoke that they're primarily going to speak about, and it's what Bob, the court had just spoke about in the section Bob read a moment ago, as far as, sorry, babe, scroll up. I got to pull it up on my side so that I don't have to do this. And sorry, Darren.
How far, babe?
It's right. I got it open. The legitimate tendency test under State v. Denny. And that's what the court's about to delve into after it gives a little bit more background.
Yeah, and there's just one thing that I think it's worth mentioning at this point. Everything that Zellner was really kind of relying on in terms of getting him first an evidentiary hearing and then hopefully a new trial basically has been rejected at this point.
Correct.
So she's going to have a decision to make as to whether or not, if she's going to continue to try to develop more newly discovered evidence, or if she's going to call it a day. So,
well, she has to appeal to the Supreme Court unless she wants everything considered up to this point waived. Like, you can't raise any complaints about issues with this opinion to the Supreme Court or to the federal court. So unless
I mean, that was going to be the next question I was going to ask you. At what point do you jump to the federal track and abandon the state? So, I mean, is it going to be Wisconsin Supreme Court, get denied there, and then you switch over to the federal track?
Yes, and they would have done that possibly on the direct appeal as well. Any issue that you don't continue to raise up to that federal court in each, let's just call it on each track, is then gone. You never get to bring it up again. So the only way to file something new again would be if something brand new, somebody came down and said something that they never said, a witness they had never heard from, didn't know existed, or they found evidence that the state hid. And that's why what you see here, that she filed like a supplement and a motion to reconsider, is because presumably, and Bob and I will be, delving into all of this on the continuing coverage, but new evidence arose while they're in the process of this post-conviction petition. So it's like, all right, well, let me supplement and get it in front of the circuit court now. So when I raise it to the appellate level, it's part of the discussion, so to speak. You don't get to go back and do it better. You only get to do it again if something brand new comes that would warrant relief.
Okay, so let's keep plowing through. In one of his supplemental post-conviction motions, Avery included an argument that the state withheld evidence, and this evidence would have established a Denny third-party perpetrator defense that Bobby had a motive to kill Halbach. The court rejected Avery's arguments without a hearing, and Avery appealed. So they're going to get into that a little bit in terms of what they're talking about, this Denny third-party perpetrator defense, and that concept that Allison was just talking about, which was the legitimate tendency test.
So when Bob gets to that portion of the opinion, you'll have a little bit of background because now we've discussed it. So hopefully you'll digest it a little easier when we get to that section.
And I do want to read footnote 2, which relates to that. So Denny which again is in a Wisconsin case, created a bright line standard requiring that 3 factors be present for admissibility of evidence that an alleged third party perpetrator committed the crime. State v. Griffin. Specifically, the defendant must demonstrate a quote legitimate tendency, end quote, that the third party committed the crime. That is, that the third party had motive, opportunity, and a direct connection to the crime.
Key word there being and. So they have to establish all 3. And I remember looking at the case law when I first read this petition, when Bob and I were working on the podcast. And as we'll see here, Bob and I actually spoke about this off pod earlier. It's very strange that the defendant has a burden to present evidence that the prosecution does not even have to convict him, i.e., establishing evidence of motive. And
I think the burden is clear and convincing as far as that goes, which is a high burden.
well, right, but I'm just saying motive is not a factor that an element of the offense that the state needs to establish in order to convict someone of murder. But an accused murderer needs evidence of motive in order to even proffer a third party culprit defense.
Yeah, I got that. I was just saying not
No, I know
only do they
you did. I'm
Oh,
talking to the people. All right,
I
Darren,
would
take
say
that
I
out
would say
too.
no.
My
I was
lord.
saying that the motive is one thing, but not only are they asking for something that isn't an element of the crime, they're asking for a very high burden to be met on top of it. That's all I was trying to say. So on appeal, Avery argued in part that the state improperly withheld evidence that Avery could have used at trial to establish that Bobby had a motive to kill Hallbach. Avery pointed to the final investigative report of Detective Mike Velli, stated saved on a CD, the Velli CD, which Avery claimed that he received in 2018. Velli created this report through forensic examination of the hard drive of a computer from the Dassey family household. Velli's report identified items such as pornography, internet search terms, and chat messages from the Dassey family computer. Avery argued that the violent pornography contained on the Velli CD could have been used as Denny evidence because it had revealed Bobby had a propensity for sexual violence and therefore a motive to kill Hallbach. Now, we were discussing this off pod. How like this concept, because you and I have pretty much landed on the concept that somebody on that property is responsible for this. Like both of us, I think we agree that I don't like I've completely rejected the concept of the cops having any hand in the killing. That's absurd to me. And I don't think anybody is following Hallbach to Stephen Avery's property and then coming back on the property and disposing of that. So to me, the only thing that makes sense is it's one of the Avery brothers or cousins or nephews. It's somebody that lives on that land.
I would
And
agree at this point. I feel the same way. And again, we're still going through all the police reports and the evidence. So our mindsets may change as that progresses. But as it stands, that's my opinion at this point as well.
and my bigger point in that is that Bobby Dassey, if that's which is who Kathleen Zeller likes for this, his motive would be the exact same thing that they're claiming was Stephen's motive. Like that, how they're saying out of one side of their mouth that Bobby has no motive, but saying that Stephen does is beyond bizarre to me. It's beyond bizarre to me.
And they'll flesh it out. So don't.
Oh, okay.
They'll flesh it out. So let's hear what the court had to say.
Okay, so we disagreed. We determined that the state did not improperly withhold evidence because it was undisputed that Avery's trial court had been given a copy of the Dassey
Counsel.
family computer.
Read that again. Counsel.
We determined that the state did not improperly withhold evidence because it was undisputed that Avery's trial counsel had been given a copy of the Dassey family computer hard drive, and the Veli CD did not contain any additional information other than what was provided to counsel. We also determined that Avery failed to establish trial counsel was ineffective for failing to analyze the Dassey family computer hard drive. We first noted that Avery's assertions that, quote, only Bobby could have downloaded the images, end quote, from a communal computer used by several people were factually unsupported. We then explained that even if the Veli CD could be used to establish the motive prong of the Denny test, that, quote, Avery failed to meet the direct connection requirement in his original Denny motion and has not presented additional evidence on this point, end quote. Therefore, Avery could not demonstrate a reasonable probability of a different outcome in trial. Allie, thoughts?
Yes, I just want to note that their issue with this CD, okay, was that it was labeled in such a way that did not lead the defense to believe that it warranted their review of it. It seemed to be. Sorry, I still didn't open it on my own end, so now I can't see it unless. All right, I opened it. I opened it. Sorry, Darren. Okay, so it was labeled, and how do we pronounce that? Veli?
Veli. Yeah,
Okay.
I think it would be Veli.
Okay, so the court, so it was labeled as the Veli CD, but it's not something that prompted the defense to review it. So they argued both that it was a Brady violation, an intentional hiding of the evidence. Yes, turned over, which is obviously what the court's relying on, but concealed nonetheless by the way that it is marked and identified by the state. Now, in Illinois, I might have argued, and it's been a long time since I read Kathleen Zellner's original petition on this, but that it could be Brady material, and Brady material needs to be specifically identified and pointed out. That might be a stretch, but in any event, that is why the defense is arguing either a Brady violation, which the court's going to go on, if they haven't already, to note has not been raised on appeal, so is waived. But secondly, that it was, and alternatively, ineffective assistance of counsel for not having reviewed it.
Okay. So moving on, in 2022, Avery filed the 974.06 motion underlying the present appeal. He first.
Sorry, babe. Rewind, Darren.
All right, quit doing that. Like he'll
All
just it makes for a shitty live though. Like he'll
Okay.
get it.
No, people here love me, I think.
I
They
don't
can
think it
deal
has
with it.
anything to do with loving you.
All right, they can deal with my all right, I'm sorry, everybody. Okay. The other thing I was going to note is their assertion, and maybe the court gets into this a little bit further, that only Bobby could have downloaded the images from a communal computer used by several people, were factually unsupported. There was more to that. There was, and you see the state do this in several trials where they identify no one else was home, everyone else was at work, things like that, where Bobby was the only one who had access to the computer during numerous time periods. Not obviously every single one of them, but enough of them to establish that it could only be Bobby, in my opinion. And we haven't gotten to all of that evidence on our continuing coverage yet, but it is stuff that Bob and I have reviewed throughout.
Yeah, like I just said earlier, I mean, we've landed on the concept that one of the Averys or Jondas did this, or Yondas. Like, no one followed Teresa onto the Avery property or was lying in wait until she left and then decided to come back and do all that heavy. I mean, we know that Stephen, if a car that didn't belong on the property drove on the property, they knew about it. Like the concept that somebody would have been creeping around to do the kind of disposal of the body that had to have taken place that wasn't somebody that lived on that property is implausible to me.
I would
So,
agree.
yeah,
They'd need to know a little bit about the Avery family's movements, who to expect home when, things like that. It'd be very, very risky and ballsy, for lack of a better word, for someone to, as you said, kind of just charge onto the property if they're not closely familiar with it.
yeah, no, and like both of us, and we haven't gotten to it in our coverage as far as Zellner's kind of her theory of Bobby and all the evidence that she believes supports that he is in fact the culprit here, and that he essentially framed his uncle, um, which is a strong theory. I mean, it really is. It's like out of a bunch of relatively creepy dudes in that family, and I feel pretty comfortable in saying that. Like Earl, Chuck, they all have some real peccadillos about their personality that are. I think if you were a woman going onto that property and you were addressed by any of those gentlemen, that you would probably not want to stay there long. Like I kind of got that vibe about them based on their history and what we know about a lot of the Averys. But this isn't
And
about them being good people or bad people. This is about whether or not and who is responsible for Teresa Halbach's death. So
And Bob's statements about, some of the characteristics or behavior of the men in the family, those come from police reports that we have, some of which we've covered on our continuing coverage and some of which we haven't gotten to yet. But I don't think it's a stretch to say that, you'd get a creepy vibe.
yeah, I mean, unequivocally. So in 2022, Avery filed his 974.06 motion underlying the present appeal. He first argued testimony from his newly discovered witness, Thomas Sowinski, quote, provides the missing direct connection between Bobby and Miss Halbach's murder, making him, Bobby, a Denny suspect, end quote. In support, Avery attached Sowinski's affidavit to his motion. So Sowinski averred that, or averred, I say averred, that before sunrise on Saturday, November 5, 2005, he was delivering papers to Avery's Auto Salvage. While there, Sowinski saw Bobby and an unidentified older male in his 50s or 60s with long gray beard, quote, pushing a dark blue RAV4 down Avery Road on the right side towards the junkyard, end quote. Bobby did not look happy to see Sowinski and attempted to step in front of Sowinski's vehicle to prevent him from leaving. Sowinski swerved, and Bobby called out, "Paper boy, gotta go." Sowinski believed that Bobby and the older individual were, quote, doing something creepy, end quote. Sowinski learned that Halbach's RAV4 was found in the salvage yard later that day. Sowinski averred that he contacted police, and an officer told him, quote, we already know who did it, end quote, as well as told him that they would contact him, but never did. Now that's got a footnote. Footnote 3 is in his initial affidavit, and these are interesting footnotes. Dated April 10 of 2021, Sowinski averred that he gave this information to Avery's trial attorneys. In August of 2022, Sowinski amended his affidavit in part to reflect that he did not give this information to Avery's trial attorneys, but instead emailed the Innocence Project in New York. He then attached the body of an email that he sent more than 8 years earlier in 2016. I remember like this particular issue. And that, like, I mean, if you're just the guy, that's delivering papers and you're trying to do something good, and you think you have information, like you're not going to know, and trying to figure out who the hell Stephen Avery's lawyer is, this deep in the process, that's a very plausible explanation.
Correct. And it's important, and the court's noting it in a footnote because this goes to, again, the procedural bars and what you have to meet. So if he had told his trial attorneys, this wouldn't be newly discovered evidence. And you need newly discovered evidence to get over the procedural bar. An ineffective assistance of counsel claim isn't going to cut it had he told his actual trial lawyers.
So the footnote continues, the January 2016 email is different from Sawinski's current affidavit in several respects. In the email, Sawinski stated that, quote, after seeing the documentary on Netflix, he decided that someone other than Manitowoc County officials needs to hear this, end quote. He wrote that, quote, somewhere between October 31st and November 5th of 2005, not sure which day, end quote, he went to Avery's property to deliver a paper. He said he ran into two people pushing, quote, a dark colored small SUV down the road. They were pushing it in the direction towards the house from the highway, end quote. Sawinski wrote, quote, it was dark and I delivered the papers as soon as possible each day so I could go home in time to get my son ready for school and drop him off, end quote. He said, quote, he didn't see who the man was on the passenger side, but the young man, maybe 18 or so, that tried to stop me was not Brendan Dassey. His build was thin and fit and about 5'9" tall, 5'9" tall. Sawinski wrote that, quote, after seeing the footage on TV of the RAV4 being on the property, it clicked that it was probably the SUV that I had seen that night, end quote. He said he called the police and notified them. They didn't seem interested at all and said, thanks for the info. Never asked me to fill out a report or even ask for my name or phone number. Okay, so that's the end of that footnote. And the court continues. In his motion, Avery asserted, quote, this new evidence allows for a reconsideration of the real motive of this crime as being a sexual homicide, which was the culmination of an obsession by Bobby with viewing thousands of images of violent, deviant pornography. On October 31, 2005, the obsessive fantasies of Bobby became a horrible reality when Teresa Halbach was brutally assaulted and murdered by 2 rifle shots to her skull. Her body was mutilated, as were many of the female subjects in the Dassey computer images. Bobby was in possession of the Halbach vehicle, which contained the crucial evidence of this terrible crime. Miss Halbach's blood, key, electronic devices, and license plate, which was concealed in another salvage car, and Mr. Avery's carefully deposited blood on the seats and dash and DNA on the hood latch. By being in possession of the vehicle, Bobby was able to control the direction of the investigation. He planted the vehicle on the Avery property after he deposited Mr. Avery's blood and DNA in it. He had Miss Halbach's key and electronic devices, which ended up in Mr. Avery's bedroom and burn barrel. Bobby did all of this to exculpate himself and to frame his uncle, Mr. Avery. Got anything, babe?
No, I mean, when you hear it like that, and I think that we may have spoken about it at some point, how crafty is Bobby? I guess you don't have to be that crafty to plant blood. I don't know. I mean, that's why we're still, like you said, our investigation isn't going to stop. We're going to go through it all so that you and I can decide,
Right.
did he do it?
Did he do it? Did he do it? Avery also argued the state committed Brady violations for failing to disclose the Sawinski evidence and for failing to disclose evidence from witness Kevin Ramlow, who averred that he observed Halbach's vehicle on the street, days after her disappearance. Finally, Avery sought a new trial in the interests of justice. So after briefing on Avery's post-conviction motion concluded, But before the circuit court decided the motion, Avery filed an affidavit from another purportedly new witness, Thomas Baresh. Baresh averred that he saw Bobby driving a RAV4 sometime before 2 a.m. on the night of Friday, November 4th, 2005, to the morning of Saturday, November 5 of 2005. Now, there's a footnote.
So this actually, I think, continues from the earlier one. So you'll have to excuse us. But
Oh, okay. Okay. Yeah, Allie's right. Yeah, it does say continued there. Okay, so this is the continuation. I shouldn't have read that. So this is the continuation of the footnote. Sawinski sent another email in December of 2020. This email is also different in several respects from his current affidavit and his January 2016 email. In the December 2020 email, Sawinski wrote, "Just finished second season," end quote. He continued, quote, "A few days before they found the RAV, I was delivering papers at about 1 to 2 a.m. and saw Bobby Dassey and another old man pushing the RAV down the road," end quote. Sawinski stated, quote, "I did call the police and they said they would contact me and they never did," end quote.
now I also want to note that at least in Illinois, and I'll have to revisit Wisconsin's law, at a post-conviction petition proceeding on the first phase, the court is not supposed to be judging the credibility of the new evidence. They are supposed to assume, if this is true, is it new evidence? And is it, compelling enough that it could have changed the outcome of trial? You can see the court here is already balancing the credibility of Sawinski, talking about how he changed his story, how he did this, how he did that. That's not supposed to be part of the circuit court or the lower court's analysis at that level of a post-conviction proceeding. They're supposed to go to a evidentiary hearing, and only at that hearing judge the credibility, reliability of the witness's new testimony. And we'll see, because the court will get through all of this in the legal analysis section of its opinion.
So Baresh averred that he saw Bobby driving a RAV4 sometime before 2 a.m. on the night of Friday, November 4th, 2005, to the morning of Saturday, November 5 of 2005. The circuit court denied Avery's motion without an evidentiary hearing on the basis that the motion was insufficiently pled. Avery appeals. Additional facts will be provided below. Discussion. So the issue in this case is whether Avery's 974.06 motion was sufficient on its face to entitle him to an evidentiary hearing. As a threshold matter, we observe that on appeal, Avery makes no argument regarding the sufficiency of his pleaded Brady or interests of justice claims. An issue, so they then cite a case, A.O. Smith Corp. Versus Allstate Insurance, quote, and they quote this rule of law from an issue raised in the trial court but not raised on appeal is deemed abandoned. We will therefore not consider them further. So
And
what does that mean?
that ends it there forever, unless there is an argument that that counsel can make to the Supreme Court that they did not abandon it, that they did somehow raise it. And again, we will get into this further during our continuing coverage about whether she did or did not abandon it. But right now, the court has ruled that it's been abandoned. So on appeal and to the federal level, that's it. Abandoned is abandoned is abandoned. Whether or not another lawyer could argue, because you got to change lawyers before someone can argue ineffective assistance of counsel. So it would require a new post-conviction appellate lawyer taking over and arguing that Kathleen Zellner was ineffective for abandoning it. And it can only be considered ineffective if it was so sufficient that it would have warranted relief. it's not, it's a high burden,
It's a
but
very high burden. I mean, anybody who watches this channel knows that once you are in the system, getting out of it is near impossible. It is near impossible. You are moving mountains, and Zellner, her record and her reputation precede her in terms of walking into these cases, and she's had zero luck here, and she's taken a couple of bites at the apple thus far. So I mean, it's really hard to do. So let's see what the court's analysis is. So as to Avery's newly discovered evidence claims and whether his motion was sufficient to entitle him to an evidentiary hearing, sufficiency of a post-conviction motion is a question of law, which we review de novo. Please explain.
that they consider it on their own. There's different standards, so they consider that um, independent of what any other court has done. It's technically from the beginning is what de novo would mean, but it just means that it's this court's own independent analysis having nothing to do with what the lower court may have said about their reasoning. That's it.
Okay, so if the motion raises sufficient facts that, if true, show that the defendant is entitled to relief, the circuit court must hold an evidentiary hearing. If the motion is conclusory, or if the record conclusively demonstrates that the movement is not entitled to relief, the circuit court may deny the motion without a hearing. So in his 974.06 motion, Avery alleged that he had newly discovered evidence from a new witness that, quote, provides direct connection between Bobby and the Hallback murder and planning evidence to frame Mr. Avery, end quote. So when seeking a new trial based on the allegation of newly discovered evidence, quote, a defendant must establish by clear and convincing evidence that, one, the evidence was discovered after conviction, two, that the defendant was not negligent in seeking the evidence, three, that the evidence is material to an issue in the case, and four, that the evidence is not merely cumulative. And that comes from State v. Edmonds.
And when they say cumulative, they mean it's not something we already heard, maybe through a different witness or in a different manner. And I think the court's gonna what they're gonna do now is go through the facts and apply it to those four factors. So I'll let the court speak to that.
So, quote, once those four criteria have been established, the court looks to whether a reasonable probability exists that a different result would be reached at trial. The circuit court determined that the Sawinski evidence satisfied the first two prongs of the newly discovered evidence test, which was evidence was discovered after Avery's conviction and Avery was not negligent in seeking the evidence. However, the circuit court stopped its newly discovered evidence analysis after it determined that Avery failed to demonstrate that the evidence was material to his third-party perpetrator defense. And now we've got a footnote. So Avery's brief to this court incorrectly states the circuit court found that, quote, Avery satisfied all the elements required to admit his newly discovered evidence, but for the materiality requirement. Because the circuit court found that Avery's motion failed to meet the materiality requirement, it did not reach the fourth prong of the test or determine whether a reasonable probability existed that a different result would be reached at trial. So the third-party perpetrator evidence is only material if it would be admissible under Denny, and that comes from State v. Volbrecht. So on appeal, Avery argues the circuit court erred by only analyzing the materiality of his newly discovered evidence within the confines of a third-party perpetrator defense. He argues, quote, in determining that Mr. Avery's new evidence could only be material to the issue of a potential third-party suspect, the court completely ignored its inherent materiality to the other material issues in Mr. Avery's case. To the extent Avery's post-conviction motion could be interpreted that the Sawinski evidence was independently material of any third-party perpetrator defense, we conclude his motion is insufficiently pled. Avery only analyzed the Sawinski evidence within the context of a third-party perpetrator defense. As one example, the fourth prong of the newly discovered evidence test requires a defendant to establish the newly discovered evidence is not cumulative. In regard to that prong, Avery offered a single sentence. Quote, the Sawinski evidence provides for the first time the missing direct connection to Bobby as a third-party suspect for Miss Halbach's murder and is therefore not cumulative. Avery did not offer any analysis that explained why his newly discovered evidence was not cumulative outside of his third-party perpetrator defense. Do you want to expand on that at all?
I was, but they're going to give another example, so I figure we could do it at the end. But so I'm just sitting here thinking this is to show all of you how the law is so form over substance. You didn't say it right. You didn't, so whether right or wrong, guilt or innocent, due process takes a back seat to form. And if you don't make a well-rounded argument in your pleadings, they're gone forever. And the court here is arguing that the pleadings, Kathleen Zellner didn't give them any other reason why the evidence meets the tests, but for the third-party culprit angle, and is now arguing in this court, in the appellate court, that the court failed to address other possibilities outside of the third-party angle.
Okay, so as another example in Avery's analysis of whether a reasonable probability exists that a different result would be reached at trial, Avery argued, if Bobby is established as a viable third-party Denny suspect, the forensic evidence in this case is completely undermined. The newly discovered evidence that Bobby was in possession of Miss Halbach's vehicle means that he had opportunity and access to plant evidence in the vehicle and from the vehicle. Because Bobby has been directly linked to the murder of Miss Halbach, there is a reasonable inference that he planted the bones in Mr. Avery's burn pit. The new evidence creates reasonable probability that had a jury heard the new evidence, it would have had a reasonable doubt as to the defendant's guilt. Therefore, Mr. Avery should be granted a new trial. So again, Avery did not offer any analysis that explained why his newly discovered evidence created a reasonable probability of a different outcome on retrial that was independent of his assertions that Bobby murdered Halbach and framed him for it. The circuit court properly recognized Avery's newly discovered evidence was not independent from Avery's attempt to meet Denny and addressed whether the evidence was material within the confines of his third-party perpetrator argument. Thoughts?
I mean, I have to revisit the petition, but based on what the court is saying here, it does appear as though Stephen Avery, by and through obviously Kathleen Zellner, didn't proffer another reason, although you can sort of see it in her reasoning, in the logic behind the argument. It's still framed, and the court relies on that. How did you frame the argument? This argument is still framed as third-party culprit evidence.
Why isn't that sufficient?
Well, what they're saying is, if you go back and look at what the court said, was that one of the issues raised on appeal was that the lower court, failed to analyze this from other angles. And the appellate court is saying, no, you failed to give them other angles to analyze it under. You insufficient. Your petition was insufficient to have them even address those other angles that you're complaining they failed to address.
But I think the question from like a normal person that's not an appellate lawyer is, why do they need to address other angles at all? If the third party perpetrator angle is sufficient enough, why do they have to argue additional?
Well, they don't, but and the court's going to I believe this opinion's gonna circle back into why the third party, culprit failed. They started to lay out that it didn't meet all of the elements, but then circled back to the fact that in his appeal, Avery argued the court wholly failed to consider, and I'm just saying it this way for layman purposes, but consider the evidence from other angles and not just as third party culprit. But to answer your other question, it's sort of a battle because like you learn in law school and what's generally said and taught and understood as appropriate is you don't want to put in every single argument. You've got to pick your strongest arguments. You're going to lose the court if you throw everything in. This is something I struggle with because I read so many cases where you didn't say this one additional thing and that's the end of it, and maybe it would have made a difference. So you want to raise other angles just in case the one that you think is going to win doesn't win.
And for the purposes of his ability to be able to move on those, are those waived?
Gone forever. Unless they're found to be so compelling that you could meet the burden on an ineffective assistance of counsel claim. But again, that would be very hard unless a higher court determined that it was such a compelling argument that the lawyer was ineffective for raising it. So I mean, it's possible, but you'd need a new lawyer. You can't raise your own ineffectiveness. And that would probably be very hard for him to get at this point because unlike your direct appeal on post-conviction in most states, and I haven't read Wisconsin specifically, but I'm going to venture to guess there as well, you don't have a right to counsel in the initial phases of your post-conviction petition. So you've got to file it on your own. Now, they don't hold you to the same legal requirements as far as drafting the petition and putting in the law to support it. But the underlying principles, yeah, that you've put enough in it to move forward. So it'd be hard pressed to him on his own as a pro se litigant to raise an effective assistance of counsel to even get to the point where the court says, all right, you did enough. I'm going to give you a lawyer. Because eventually you do reach that level, but not in the initial pleadings. You've got to get past the court saying, okay, there's enough here. I'm going to let you move to stage 2 and I'm going to give you a lawyer to do it.
So, for the purposes of my own edification, can you give me, like, essentially what we have here is like, okay, look, Kathleen Zellner decided that she was going to lean completely into the third party perpetrator argument. Okay.
Or
They
at least
be
that's the way the court has interpreted it.
right. And they pick it apart primarily by saying, look, Sawinski's affidavits are spurious in that he's changed his story 3 times. He sent it to the wrong person. We'll get over that fact. We'll get over the fact that he sent it to the wrong lawyers. However, we find that his inconsistencies within the statements themselves, where he's saying, I probably, using the word probably, talking about a small SUV, and now he's definitive that it was the SUV. Those kind of things put the appellate court's mindset of like, all right, that's not enough for us. But my question to you is, what is an alternate argument? What else could she have argued in terms of this evidence that they're proffering?
I mean, I think it sort of has something to do with them being able to put forth a defense in the same sense as they put enough in to argue to the jury that the police framed him. They dropped that key there, that they could have argued that Bobby framed it seems like that was maybe where she was going, that Bobby had the ability to frame him and that would have cast doubt on his guilt. But in order for Bobby to be the one to frame him, Bobby also has to be the one to have committed the offense, logically speaking. So the court again ties it back to third party. Now, I'd have to re-review Kathleen Avery's petition in order to
Eleanor.
see I'm sorry, what did I say?
Kathleen Avery. She probably
Oh,
wouldn't appreciate that.
I would have to revisit Kathleen Zellner's original petitions and supplements to recall what else might have been there to raise. I do think that there are other angles, and I venture to guess they are included in there, but again, the court wants it to be like a very specific kinda heading, a very specific argument, not a sentence here or a sentence there. It has to be well fleshed out. It has to apply the law. They're very particular on a, an argument that is not adequately fleshed out under the law and in the petition is deemed waived.
All right, let's move on. So Avery next argues the circuit court erred by denying his post-conviction motion because he asserts his newly discovered evidence satisfied Denny's legitimate tendency requirement and established that Bobby emmed, unalived Hallbach and framed him for it. Avery contends the circuit court erroneously imposed a substantial certainty requirement and misapplied Denny in its evaluation of whether Avery's proffered evidence satisfied the Denny elements of motive, opportunity, and direct connection. As stated previously, third-party perpetrator evidence is only material if it would be admissible under Denny, and that comes from Volbrecht. Under Denny, the defendant must show, quote, a legitimate tendency, end quote, that the third party committed the crime, which is demonstrated by establishing the third party had motive, opportunity, and a direct connection to the crime. And that comes from State v. Wilson. Defendants, before I jump there, there's a footnote. I don't know if I missed it from up above. I don't know where 5 was. Okay,
It's
so
it's just under the first citation to Volbrecht. So here the court in its footnote is going to give a little bit of background of the Volbrecht case and its holding.
Okay, so in Volbrecht, we affirm that the circuit court's grant of a new trial on the basis that the newly discovered evidence satisfied the requirements of Denny and created a reasonable probability of a different outcome on retrial.
So that was a situation where the state appealed a court finding that they did meet the Denny test.
Okay, so under Denny, the defendant must show a legitimate tendency that the third party committed the crime, which is demonstrated by establishing the third party had motive, opportunity, and direct connection to the crime. A defendant's offer of proof on these 3 prongs is insufficient if it merely establishes a bare possibility that the third party could have been the perpetrator. Now, we will start with motive. Motive refers to a person's reason for doing something. In evaluating the motive prong, we ask whether, quote, the alleged third-party perpetrator had a plausible reason to commit the crime. In his post-conviction motion, Avery asserted that Bobby had motive to kill Hallbach because Bobby searched for violent pornographic images on the family computer, which established Bobby had an obsession with violence and was more likely to commit an unaliving. In support of his theory, Avery first alleged in his motion that there were 1,625 violent pornographic images recovered on the Veli CD. He stated the recovered pornographic images, quote, depicted violent images of the torture and mutilation of young females, end quote. These statements are not supported by the record citations offered by Avery in his post-conviction motion. His computer expert's affidavit, which he cites in support of his first proposition, does not establish that there were, quote, 1,625 violent pornographic images on the Dassey family computer. The report simply states that there were, quote, 1,625 additional images categorized as recovered pornography. And that's a quote. Nothing in this affidavit established that each recovered pornographic image was violent. As for Avery's next assertion, that the recovered images depicted violent images of the torture and mutilation of young females, Avery cites pages from his computer expert's affidavit in support of that proposition. However, again, the page citations offered by Avery do not establish the pornographic images were violent images of torture and mutilation. At best, the citation provides that the Veli CD contained 2,632 search results for terms. And then they now break it down. One, or I, these are Roman numerals. I, blood, one result. Roman numeral 2, body, 2,083 results. Roman numeral 3, bondage, 3 results. 4, bullet, 10 results. V, cement, 23 results. 6, DNA, 3 results. 7, fire, 51 results. 8, gas, 50 results. 9, gun, 75 results. X, which is 10, handcuff, 2 results. 11, journal, 106 results. 12, MySpace, 61 results. 13, news, 54 results. 14, RAV, 74 results. 15, stab, 32 results. 16, throat, 2 results. And 17, tires, 2 results. These search terms in no way establish that pornographic images were violent images of torture and mutilation. That may be true, but they're awfully cozy to a lot of the facts that are involved with this case. You know, like, why are there 74 search results for a RAV or a RAV4?
Yeah. I mean, I'm sure there was more context given at some point.
I
In
mean,
the
to me, the RAV is the most striking. You know, I mean, like, obviously your mind can go to the concept of the cement, the gun, news,
right, it could
you
all
know.
be nothing, but they do own a a car
I don't think Bobby
salvage.
worked. I don't think Bobby worked for the salvage yard, though. But the bigger argument from them is that the 3 boys and Barb, who I think has been known to have stated, I never go on the computer. I'm a Luddite. So that would leave the boys. And I believe at that point, I can't remember if all 3 of them lived there. If Bobby and Brendan and what's the third brother? David? I can't remember.
I'm not sure.
Okay, so that being said, we recognize the record does at least suggest there were some pornographic as well as gory images found on the Dassey family computer. We will therefore assume, for the purposes of Avery's post-conviction motion, that there was some quantity of what could be classified as violent pornographic images found on the communal computer. See, they're very careful to always state it as the communal computer.
Right, and the reason that they do that is because, when it goes up to a higher court, the question becomes, did the lower court even did they properly consider the record? And when a court says, well, I think it's this way, but even assuming it's this other way, X, Y, and Z, that'll satisfy a higher court that at least the lower court considered it. If they considered it wrong, they alternately considered it, correctly.
Okay. So, however, even with that assumption, the fundamental problem with Avery's motion is that he fails to tie these violent pornographic images to Bobby. In his post-conviction motion, Avery attempted to tie these images to Bobby by arguing that because Bobby routinely worked night shifts and was home during the day from 7 a.m. to 3:30 p.m., while other members of his family were routinely at work or at school, it followed that Bobby conducted the searches for these images. This is conclusory and speculative, which is followed by a footnote So in support of his assertion that, quote, there is sufficient evidence that it was only Bobby who had access to the Dassey computer during the day on weekdays between approximately 7 a.m. and 3:30 p.m., Avery offers in part a record citation to his state's brief. In the record citation offered by Avery, the state argued this passage
Wait, there's a
demonstrates
passage.
what?
There's a passage above it, I think.
Oh, yeah. Thank you. The computer was accessible to numerous people. Brendan Dassey, Blaine Dassey, Scott Taddick, Brian Dassey, Bobby Dassey, Barb Janda, and Tom Janda all lived in the house or had visited the house up until October 15th of 2005 when Tom Yanda moved out. The four Dassey brothers and Barb Yanda lived in the residence from October 31, 2005 to March 1 of 2006 when Brendan Dassey was arrested. Stephen Avery was a regular visitor to the Dassey house, giving him access to the computer as well. So this passage demonstrates the need for non-conclusory evidence establishing Bobby was the individual who searched for the specific images of the alleged violent pornography.
And I'll just indicate that I do specifically recall these searches continued when Stephen Avery was in jail. So it couldn't have been Stephen Avery, and there was, I believe, much more indicated in the pleadings that point to it being Bobby. And where the court calls this conclusory and speculative, I would say it's the amount of circumstantial evidence the state often relies on when building, quote, a circumstantial case. So when it's the state or when the court wants, it's circumstantial evidence, and circumstantial evidence can be completely appropriate to establish X, Y, and Z. When the court doesn't want it to be that way, it becomes conclusory and speculative. And again, I have not decided that Stephen Avery is innocent by any stretch of the imagination. And yes, this is called defense diary. So you're getting the defense attorney's mindset on this. But I'm just saying, I have seen in cases them use this very same logic to provide circumstantial evidence of a defendant's guilt for things like searches on a communal computer and who's home at the time and who's often gone at the time. So I do know that there was more in the petition that pointed to it being, Bobby, and maybe not every occasion, but several. And there was definitely periods of time where Stephen Avery was incarcerated on the earlier charge that he was exonerated for.
Yeah, and my opinion on this thing is I mean, since we really started digging into it, was that Bobby's a likely suspect in the sense that he had access to the property. And it goes back to what you were saying initially that it's frustrating if you're looking at this from the outside looking in that there's not kind of a what's good for the goose is good for the gander approach with respect to this, because I mean, all they're saying to do in terms of, and they being Zellner and Avery, is take Steven out of, take Steven's name out of it and plug Bobby's in, and everything else is the same. Like the motive, the opportunity, and the direct connection. I mean, everything is the exact same. That's why you were saying like we gotta kind of tear it down at this point, because it's like at trial you have one thing that you have to try to establish as the prosecution, and that you have the opportunity to try to rebut at trial as the defendant. But it's like something entirely different when you get to this level. Once that person's been convicted, now what was clearly in the eyes of the jury enough for them to convict him now is not enough for the appellate court to even give him an evidentiary hearing.
Right, not even enough to establish clear and convincing, let alone beyond a reasonable doubt. And
And
again, in
and
your
it's the
first
same concept, exact same concept. It's plug and play. You pull Avery's name out and you plug Bobby's in. Everything else is the same.
well, they did find the key in Stephen's bedroom, and they did find blood that I'm going to assume hits on all alleles to be Stephen, because Bobby obviously is gonna have very similar DNA, um, but not the exact same, and I do know that they employed Dr. Reich, so if there could have been an argument that that DNA could have been another family member, it's something that we would have heard, or maybe they'll get into here, but I don't think so.
Yeah, I don't think so either. And Reich wouldn't have missed it. I mean,
No.
that's his. Okay, so moreover, to establish Bobby's purported obsession with violence, Avery alleged that 128 searches for the most violent porn images primarily occurred on weekdays when only Bobby was in the Dassey residence. And that's a quote. In support, Avery cited his computer expert's second supplemental affidavit. However, of the searches listed, only 28 of them occurred between 7 a.m. and 3:45 p.m. on a weekday. Then, of those 28 searches, only 3 of them occurred before Halbach's murder. So, even accepting Avery's unsupported speculation that, quote, only Bobby had access to the Dassey computer, end quote, during that time frame and conducted the searches, and assuming that the 3 searches were, in fact, for violent pornography, Avery failed to explain in his post-conviction motion how someone only possibly having searched for pornography 3 times established his theory of motive, that, quote, Bobby had an obsession with violence and therefore was more likely to commit the murder. His allegation is conclusory and speculative. So the circuit court found that Avery's motion was insufficiently pled because Avery provided nothing that would establish Bobby was the one who conducted the searches for the pornography found on the Dassey family computer, or that he was even at home at the time the searches were conducted. The circuit court also observed the searches used were generic and broad and did not closely resemble anything about this case. Circuit court noted that there were only a small amount of searches that occurred before Halbach's murder. The court also observed that the two expert opinions Avery submitted were based on the unsupported assumption that Bobby conducted the searches and were produced without any forensic or psychological examination of Bobby himself. We agree with the circuit court that Avery's post-conviction motion does not sufficiently allege non-conclusory facts that Bobby had motive to kill Halbach. We could stop the analysis here. After all, by failing to sufficiently allege non-conclusory facts demonstrating Bobby had a motive to kill Halbach, Avery has not established that his newly discovered Sawinski evidence is material for his third-party perpetrator defense. See Wilson. The Denny test is a 3-prong test. It never becomes a 1 or 2-prong test. Let me see, where's 8? Okay, so footnote 8. Oh, wait, I think there's footnote 7 too. Okay,
Yes.
so
So the circuit court noted in the portion of the opinion where they indicate that the circuit court noted that there were only a small amount of searches that occurred before Halbach's murder, the court went on to state in a footnote, in his brief to this court, Avery argues the circuit court erred by determining only a, quote, small number of searches occurred before Halbach's murder. He asserts that, quote, on September 18th, 2025, there were 75 searches of violent child or underage pornography performed on the Dassey computer, obviously prior to Miss Halbach's murder, end quote. In support, he does not cite to a fact pled in his post-conviction petition. Instead, he cites to one of the 84 exhibits he attached to his post-conviction petition, specifically a supplemental affidavit from his, quote, police procedure expert. It is unclear the foundation for this expert statement. After all, as Avery pled in his post-conviction motion, his computer expert identified, quote, 128 searches for the most violent porn images, end quote. And that expert's affidavit reveals that none of these searches occurred on September 18th, 2005. More importantly, September 18th, 2005 was a Sunday, which is when multiple individuals had access to the communal computer. Assuming searches for some kind did occur on Sunday, September 18th, 2005, Avery does not explain how these searches can be tied to Bobby. We will not consider this argument further. Now, I just want to note here, you asked me earlier, what else could this evidence been used to demonstrate? Without pointing to a specific person, I think the argument could have been made at trial that someone with close ties to the property and or the family, who's often on the property and has access to the yard, his house, whatever the case may be, has these violent tendencies. And that in and of itself, without identifying a third person, could be used to show that someone who has this close connection has this diversion, or what's the word? Sorry.
Predilection.
Yes. That someone close to the property and the family has these predilections, and that's significant. So that's an argument that exists within the boundaries of what's already been pled that the court could have considered when determining whether this evidence, this newly discovered evidence, is material. And it could have been material for the purposes of demonstrating that there's somebody out there without identifying who that somebody is specifically.
Why don't you go ahead and read footnote 8 as well?
So when the court indicated that they agreed with the circuit court that Avery's post-conviction motion does not sufficiently allege non-conclusory facts that Bobby had motive to kill Hallback, the court went on to note in its footnote, in his brief to this court, Avery contends that if Bobby's motive was not sexual, quote, the motive for her murder may have been a theft by Bobby of her vehicle and the items within it, end quote. This was not pled in Avery's post-conviction motion. It is also conclusory and speculative. We do not consider this argument further.
And I hate that motive. It's the worst motive of all time. Like he wants to steal a RAV4. For what purpose? You can't drive it around.
Right.
Okay, so Denny requires that all three, which are motive, opportunity, and direct connection, be shown before evidence of a third-party perpetrator is admitted at trial. However, in the interest of completeness, we will continue the analysis. We next turn to the second prong of the legitimate tendency test, opportunity. Opportunity, quote, asks whether the alleged third-party perpetrator could have committed the crime in question, end quote. Wilson, quote, the defense theory of a third party's involvement will guide the relevance analysis of opportunity evidence in a Denny case. Sometimes opportunity can be established by simply showing the third party was at a crime scene. However, when the theory of how the third party committed the crimes requires that person to have carried out a series of complicated and difficult tasks, it is not enough to show that the third party's mere presence at the scene and an unaccounted for period of time. In his present motion, Avery alleged that Bobby killed Hallback on October 31 of 2005 and then framed him for it.
And in a footnote, the court indicates, in his brief to this court, Avery complains, quote, the circuit court erroneously found that Miss Hallback was murdered on October 31st, but there is no proof of when Miss Hallback was murdered up until her remains were found on November 7th. However, in his post-conviction motion, Avery specifically alleged, quote, on October 31st, 2005, the obsessive fantasies of Bobby became a horrible reality when Teresa Hallback was brutally assaulted and murdered by 2 rifle shots to her skull, emphasis added, and that emphasis was on the date. And here you have again, it's a version of form over substance. It's tantamount to the court binding him to that date because of the way it's worded, when really, come on. But that's the way the law is. It's like, you admitted it. You said on October 31st, 2005. So now don't try to tell us the court should have considered that it could have happened anywhere between October 31st, 2005 and November 7th.
I mean, the reality is, the likelihood is that is when it happened. I mean, where would he have holed Teresa Hallbach up for days where no one is able to locate her? Like where is she, if she's alive, that she's being kept without anybody being aware that she's being kept captive? You know what I'm saying? Like where could that have been?
I absolutely agree with you. I turn on my lawyer cap for this analysis and just kind of pointing out that, you know, the, the way that kind of plays out and how the courts do those things. But I 100% agree with you that I don't think there can be a good faith argument that it occurred on another date. However, for the purposes of legal argument and a brief, it's not a fact established through the evidence. It's just not. So it leaves that opportunity open for the purposes of a legal argument. But when we're talking about this as just people analyzing what might have happened that day, 100% agree. It's very likely that it occurred, on that day. But could someone have held her, kept her hold up somewhere? Sure. You know,
If there's two people involved. I mean, that's
right. Or you talk about people who've got their little, shack where they've got somebody chained. Again, here, there's no evidence that she was chained, but there's also no evidence she wasn't, because her body was too, they could not tell based on how the body was burned and disposed of. But, in a vacuum, the killer could have taken the victim to a third location, held her there. I forget what day. I'm assuming that the Sawinski affidavit said that he saw this on October 31st, or the morning hours of November 1st. So factually, it doesn't tie into what they're arguing anyway, to argue this could have happened at a later date.
Yeah, I mean, to me, the concept of keeping somebody alive and captive is a much different circumstance than the homicide could have occurred somewhere else. Yeah, like, I mean, I think that's fair to say that very likely, if Bobby Dassey followed her off the property, which I think there's some pretty decent evidence that she may have actually left that property. I mean, there's some evidence that exists out there that she did in fact pull off the property. I know that there's affidavits out there where somebody saw that vehicle out and about on the road.
And then parked in the same place numerous days in a row.
Right. That was the whole license plate thing with what's his face. But like unaliving somebody in a different location, which could theoretically and would leave that person scent for a scent dog, does not mean that they've kept them captive there. It's a whole different thing. Keeping an alive person captive is a massive undertaking, and you're not going to be able to do it in a deer stand, and you're certainly not going to be able to do it in an open area where that person's just going to, like, unless they're being guarded 24/7. Like, so kind of those concepts of it, like I lean heavily towards that it occurred on or around the 31st, either shortly after she left or at some point during the course of that evening. So therefore, to establish opportunity in this case, Avery must provide some evidence that Bobby had the realistic ability to engineer such a scenario. So Avery contended that Avery contended that Sawinski's affidavit established Bobby was in possession of Halbach's vehicle and, quote, had the opportunity access to the items that were used in the frame-up, end quote. He stated Bobby was in possession of the Halbach vehicle, which contained the crucial evidence of this terrible crime. Ms. Halbach's blood, key, electronic devices, and license plate, which was concealed in another salvage car. And Mr. Avery's carefully deposited blood on the seats and dash and DNA on the hood latch. By being in possession of the vehicle, Bobby was able to control the direction of the investigation. He planted the vehicle on the Avery property after he deposited Mr. Avery's blood and DNA in it. He had Miss Halbach's key and electronic devices, which ended up in Mr. Avery's bedroom and burn barrel, respectively. So the Sawinski affidavit, however, only stated that Sawinski saw Bobby and another individual pushing a blue-colored RAV4 on November 5, 2005. Nothing in the Sawinski affidavit linked Bobby to Halbach's RAV4, its keys or his electronics. Talking about form over substance. Wow.
It's ridiculous.
It's ridiculous. Avery failed to offer anything other than speculation that Bobby possessed Halbach's RAV4, its keys, or her electronics. I mean,
if he possessed the RAV4, obviously he had access to the things inside it, her key and her electronics.
I mean, that is but no matter what you think about innocence or guilt of Stephen Avery in this, that is incredibly disingenuous. I mean, because if you're to assume, just to assume for argument's sake that this Bobby Dassey theory is the correct theory, for them to say, okay, well, they've got eyewitnesses seeing him pushing the vehicle, to not take the next logical leap, which would mean that he had access to the things in that vehicle that he was pushing, is absurd to me. It discredits their thought process to me quite a bit when they do things like that. I don't know why they need to do that, because it's not fleshed out by them. Talking about speculation or just failing to take logic into consideration, it's strange.
And again, when you're talking about the state's burden and when people are trying to convicted defendants are trying to appeal based on insufficiency of the evidence or something like that, based on an argument the prosecution made that was not supported by the evidence, the court always says logical inferences from the evidence. That's what they look at. Logical inferences from the evidence. They're not applying their own basic, everyday legal
principle.
Correct.
So, I mean, because when you look at it, Avery failed to offer anything other than speculation that Bobby possessed. If Zellner would have fleshed it out, how does that change it from being speculative?
No,
So
I think she
Bobby
did flesh it out. I think they're just saying it's speculative.
Right. Well, it says nothing in the Sawinski affidavit linked Bobby to Halbach's RAV4, its keys, or her electronics.
Right, but right above it, they said that they saw Bobby pushing a blue-colored RV on November 5th. That, I mean, that is her saying, and she did very clearly flesh out that person that he saw was Bobby. That blue-colored RV was her RV, or could have been. The logical inference that he's pushing a blue-colored RAV in the middle of the night and behaving the manner he was behaving, the logical inferences of that is that there's at least a, quote, reasonable probability that it was Teresa Halbach's RAV4.
Yeah, that's not what I'm saying, though. And what I'm saying, and you've had the opportunity to read Zellner's post-conviction petition. I have not. What I'm saying is this language here. So they italicize pushing for emphasis. Okay. So what I'm saying is and I'm asking you because I don't know the answer. Does Zellner flesh out her whole theory?
Yes.
So that Bobby had, obviously that after he takes out the key, after he plants the blood, that's when he's pushing the vehicle onto the salvage yard puts it in the position where it's ultimately found, covers it with the branches, puts another car hood on top of it, takes the plate off and puts it in another vehicle in the yard. Like, so she lays that all out.
Absolutely.
So why are they saying that Avery failed to offer anything other than speculation that Bobby possessed Halbach's RAV4? I mean, all of this is speculation.
Correct, but they're saying that the court is saying that just him pushing a blue-colored RAV4 doesn't make it Halbach's, that's pure speculation that it would actually be Halbach's.
But you just told me that she fleshed out the whole argument that he was they killed her. He had the car. He then took the car key. He went and got Steve's blood from off his sink, scraped it off, somehow got it like liquid again and put it all in the, I mean, you say that they spell that out. So I don't understand. I'm lost in terms
Again,
of.
I'm going to say it this way. Okay. Assume all those things are in there. What the court is saying is that the key factor to be able to say any of this is Solinsky saying he saw Bobby pushing a blue-colored RAV4 on November 5th, 2005. And the court is saying connecting that blue-colored RAV4 to Teresa in order to make all the other assumptions is speculative.
What?
You and I are saying that's ridiculous. That's disingenuous. But that's what I'm reading they're saying. That's how I'm taking what they're saying there.
Well, I'm taking it the same way. The fact of the matter is because I haven't read the post-conviction petition, they're making it seem as if she didn't flesh out the entire scenario. I mean, for them to be saying, okay, well, she just says that Sawinski says he sees him pushing a vehicle. Like, okay, well, who else's vehicle? There just so happens to be another blue-colored RAV4 that he's pushing on the day that she happens to go missing.
Exactly.
I mean, or 5 days later, 4 days later, whenever he sees it.
Exactly, which is why we're saying it's a very disingenuous argument for the court to make, and it ignores how they typically use reasonable inferences from the circumstances and the evidence.
All right, let's keep plowing through. So additionally, although Avery argued Bobby had access to his blood, Avery claimed that Bobby knew Avery was bleeding one day and that Avery left blood in his trailer sink. Avery only offered conclusory statements and speculation that Bobby would be able to successfully collect and plant Avery's blood in a way that went undetected by crime scene professionals. What let me ask you this, and this is a legitimate question. Conclusory and speculative state, like what else do they want from the defense in this situation? Like you're positing a theory of what happened the same way that the state did in their case in chief against Steve and Avery. They weren't there. Kathleen Zellner was not there. What do they expect her to do other than to posit a theory of what she think happens that day, using the evidence and believing that the evidence, I mean, when you kind of look at it like that, and I'm asking you, what could they possibly want? What would they expect her to say there?
So just thinking, possibly one of the things could have been that Bobby would have similar DNA. So if a slight amount of his DNA got mixed in, it might not be distinguishable and it would still show Avery's DNA. Or B, something from Reich, for example, that says one would only have to use a Q-tip, and in such a case, DNA would not be of the person planting the evidence would not be left behind. But those are both things that you don't need an expert to say. It's just something that is known to people. So again, I just take it as and again, I'm not saying that Stephen Avery is innocent. I'm just critiquing the court's ruling here, its opinion and its logic to say I believe they're just being disingenuous. I don't think that he should have had to do anything more. And adding words that I just kind of threw out there, that again is a super form over substance thing, especially when you're saying common sense dictates that either you can wear a glove or use a Q-tip and that person's DNA wouldn't be the planting DNA wouldn't be left behind.
Yeah, and for y'all, if you don't know that we've got 11 in the can. We are doing the deepest dive ever on this case, ever. And only at the end of it will you hear what our opinion as to innocence or guilt is. Like, that's the only time we're going to talk about it, because Alice and I are very clear that we don't care what other people are saying about it. Like, we understand that people have opinions on it. We respect those opinions. We understand that people have dug into this case for years, have invested huge amounts of time into examining this case and the evidence and reading the pleadings. And we understand all that and we respect it. But that's your opinion. Point being that we're going to do the same thing and we're going to form our own opinions. And you can either accept it or you can reject it. But I mean, we can't reach that opinion based on just on what other people are saying without doing the work ourselves. So, and we're willing to do it and we're going to do it no matter what the result of this is. But and I think kind of the bigger point, babe, is that what disturbs me most about this is that they like to throw out these terms like conclusory and speculative. You know how those all could have been fleshed out with an evidentiary hearing. Like the fact that they're just denying him the evidentiary hearing is what's most disturbing about it, because that's when she can develop more evidence through cross-examination, through direct examination, and they're just not allowing her or Stephen Avery to do that, which is really what kind of bugs me the most about this opinion. Like, I'm a big fan of, if there's enough question, like, who does it hurt except maybe the Halbach family, which I think is a legitimate claim. But who does it hurt in terms of the search for justice and the truth to have the, because if we had gone through an evidentiary hearing and we're able to read through that, and I'm like, well, you're right. After all of that, I still feel like this is just complete speculation. I don't think she was able to tie anything up as neatly as you'd need in order to get this thing back on a remand. But we're not there. We're not there. And I always have an issue with that. Like, test the evidence in all cases. Just test the evidence. Like that. There's never an excuse for me that's viable that they should not test any evidence that they have, that at the time they didn't have the ability to be able to test it, but now they do. You test that evidence. We're trying to get to the truth here, always, in every single case. So Avery also did not explain how Bobby had access to any of the other forensic evidence in the case. In his post-conviction motion, Avery omitted any allegation that Bobby had access or ability to collect and transfer his DNA, which was found on Halbach's hood latch and her RAV4 key. Avery also omitted that police found a bullet inside Avery's garage that contained Halbach's DNA, and the bullet was fired from a rifle that was found inside Avery's trailer.
Now, the court has a footnote here. Sorry,
I got it there, or if you can read it from my screen.
In his brief to this court, Avery states that he maintains law enforcement planted the touch DNA in this case. However, in his post-conviction motion, he alleged Bobby deposited Mr. Avery's DNA in the vehicle. And I don't know, they might have been offered as alternative theories. I'd have to revisit the brief, but that's what the court is finding.
Moving on. So the circuit court observed that, pursuant to Wilson, Avery's theory of Bobby's involvement required Avery to provide evidence that Bobby had the realistic ability to carry out the complicated plan that he alleged was used to frame him. See Wilson. The court noted that Avery, quote, speculates on many points as to how Bobby could have carried out the plan to frame Avery, but the Wilson test requires more, end quote. The court determined Avery and this is a quotation, failed to offer any evidence that Bobby had the scientific knowledge to recognize the significance of each piece of the forensic evidence supposedly planted by him, let alone establish that he had the skill to plant that evidence in a way that would stand up to scientific scrutiny by professional crime scene analysts. End quote. Court concluded that all of the allegations implicating Bobby in the murder and the framing of Avery are pure speculation and not supported by any evidence submitted by Avery. We agree with the circuit court.
And again, the court has a footnote there. In its analysis, the circuit court also observed that Avery's new defense theory that Bobby murdered Hallback and framed Avery for the crime failed to acknowledge Bobby's brother, Brendan Dassey. The court observed that Brendan Dassey confessed to and was convicted of participating in Hallback's murder, that Brendan, quote, specifically implicated Avery in this crime, and that Brendan's conviction was affirmed by the appellate courts. That's a hard pill to swallow.
It is.
And if you don't know about Brendan Dassey, we do discuss that, and we'll discuss it further in our ongoing coverage of this case on the podcast.
So we conclude Bobby's mere presence on the Avery property and the Sawinski affidavit averring that Bobby was pushing a RAV4 5 days after Hallback's murder does not establish any fact showing Bobby could have actually accomplished committing Hallback's murder and planting all of the evidence in this case. Nothing in the Sawinski affidavit establishes Bobby was in possession of the evidence that Avery asserts was used to frame him. In short, Avery's post-conviction motion fails to allege sufficient facts to support his theory that Bobby had opportunity, that he could have killed Hallback and framed Avery for it.
And, that is a question that you and I pose on the pod. We did talk about, like, how savvy is Bobby? Is he going to go through all of that? Like, oh, I remember my uncle was bleeding. There might be blood in his sink.
I mean, you've got to try to work that through. I mean, you always have to try to play these things out, these theories out in your mind, or in our case, between ourselves, and give each other some devil's advocacy and poke and prod. And I mean, I think that one thing that's clear is that Stephen is no genius. I mean, it's like you kind of have this case has always fascinated me because of a few factors, and it's that Stephen Avery had been in for 18 years on something that he did not do. He gets out. He's got a rather large lawsuit pending against Manitowoc County, amongst others. And, I don't think he was going to get the 40 million he was asking for, but I think that he would have gotten millions. On top of that, you've also got the scenario that this film crew who ended up, being in position to film all of this because they were doing a documentary on his first wrongful conviction. So you've got money coming. You've got a film crew that's following you around. You have to kind of accept the fact that Stephen Avery was so compelled to do this that those two things, what I consider to be major factors, did not matter to him at all, that he could not control the compulsion. Like, I mean, this dude was on the radar. I mean, he literally, and then to commit the crimes and be so stupid to park the vehicle on his own property, to drop the key in his own bedroom, to leave his, like, I mean, the guy went through a process in terms of a full trial on his first case. I mean, genius or not, the guy had to have some kind of basic understanding that if he leaves a woman who has disappeared, her vehicle on his property, that they're going to think that he probably did it. And on top of, it's like, you have to really, like, that's the thing about this case that always has me wondering. You know, he left so much evidence on his own property where it's going to be known. He had to know that they would be, they would come calling like, hey, we know because you called Auto Trader that she was here and you were, as far as we know, her last or second to last appointment. He had to know that. He had to know that he called Auto Trader. Like, it's just like, that is the thing that makes this case, to me, worth our time looking into. It's those prospects which I just have a very hard time understanding how anybody could be that stupid.
Agreed. But unfortunately, you're going to have to bring the rest of the court's opinion without me. I do have a 12 o'clock appointment.
What? No. Just tell them you're 15. Just email them. Tell them you're 15 minutes late.
Jesus.
We're close. We have four pages left. I'll whip through. All right. So we all want Allie here, right? We don't want her to leave, right, guys? Let's get some Team Allie's going in the chat here so she feels the love.
I feel the love, but it was hard, okay. I'm sending an email. Sorry, Darren.
Okay, so we could again stop the analysis here. In his post-conviction motion, Avery had already failed to sufficiently plead 2 prongs of the Denny test. Once more, in the interest of completeness, we will complete the analysis. The third prong of the legitimate tendency test is a, quote, direct connection. And that, again, comes from Wilson. Direct connection is assessed by considering, quote, the proffered evidence in conjunction with all other evidence to determine whether, under the totality of the circumstances, the evidence suggests that a third-party perpetrator actually committed the crime, end quote, and takes the defendant's theory, quote, beyond mere speculation. And that's Id Wilson one more time. So, quote, no bright lines can be drawn as to what constitutes a third-party direct connection to a crime, end quote, but it must be more than, quote, a connection between the third party and the crime, end quote. It requires, quote, some direct connection between the third party and the perpetration of the crime, end quote. So in his post-conviction motion, Avery argued that Sawinski evidence demonstrates that Bobby could have committed the murders because he is in possession of Miss Halbach's vehicle, where the murder likely occurred, as evidenced by Miss Halbach's blood in the vehicle. The vehicle is a key piece of evidence in the crime, end quote. The circuit court disagreed. It stated, quote, assuming for the purposes of this motion that everything averred to in the Sawinski affidavit is true. The defendant is incorrect in his assertion that the facts in the affidavit provide a direct link between Bobby and the Halbach murder. The defendant asserts that ipso facto, if Bobby was in possession of the victim's car that night, he must have been the individual who committed the murder. No evidence submitted by the defendant supports this conclusion. Even if Bobby was found in possession of the victim's automobile on the night of November 5th, 2005, there is only speculation and no evidence to prove that Bobby was in possession of the car or that he had exclusive control over the vehicle prior to that night. We agree with the circuit court. Sawinski's averments that he purportedly saw Bobby and someone else pushing a RAV4 on November 5 days after Halbach's murder, do not provide a link between Bobby and the perpetration of the murder, nor any factual link between Bobby and any of the forensic evidence. At most, Sawinski's affidavit establishes a possible, quote, connection between the third party and the crime, end quote, see Wilson. However, that is not enough. Avery's post-conviction motion does not sufficiently allege facts that demonstrate Bobby had, quote, a direct connection to murdering Halbach and framing Avery for it. See Wilson. Because Avery's post-conviction motion did not allege sufficient facts to satisfy the Denny requirements for the third-party perpetrator evidence, the Sawinski evidence is not material and therefore does not satisfy the newly discovered evidence test. See Volprecht. We therefore do not determine whether the, quote, evidence is not merely cumulative, the fourth factor, or whether a reasonable probability exists that a different result would have been reached at a new trial. See Edmonds. Avery's motion is insufficiently pled. Now we pause here to discuss the affidavit from Baruch. As stated previously, after briefing on Avery's post-conviction motion concluded, Avery filed an affidavit from Baruch. Avery's post-conviction counsel moved to amend a single paragraph in the post-conviction motion so that amended paragraph would read, paragraph 20, the Sawinski evidence provided by Mr. Sawinski to Mr. Avery's current post-conviction counsel is newly discovered evidence which provides the missing direct connection between Bobby and Ms. Halbach's murder, making him a Denny suspect. Mr. Thomas Baruch corroborates the previously filed affidavit of Thomas Sawinski that Bobby Dassey was driving the RAV4 vehicle of Teresa Halbach on Friday night, November 4th, or early Saturday morning after her disappearance on October 31, 2005. The circuit court analyzed Baruch's affidavit and determined nothing in Baruch's affidavit linked Bobby to Halbach's murder. We conclude Avery's motion is insufficiently pled in regard to the Baruch affidavit. Avery referenced Baruch one time in the entirety of his post-conviction motion. He did not offer any analysis or assertions within his motion as to how Baruch's affidavit met the 4 criteria of newly discovered evidence or established a reasonable probability that a different result would be reached at trial. Avery did not sufficiently plead the Baruch affidavit as newly discovered evidence. In any event.
I was going to let you finish that sentence.
Okay, in any event, we agree the circuit court that Baruch's affidavit does not link Bobby to Halbach's murder.
So there you see in black and white and fleshed out, it's not enough to just say it. You've got to take each new piece of evidence and go through this 5-part analysis. You've got to show for each one. And you specifically say, okay, this piece of evidence, now let me apply the test. Okay, this piece of evidence, now let me apply the test. Even when you've just stated the test and it's clearly a continuation of that test, and that's a very typical outcome in appellate opinions. So I just want to go on note as also saying there's nothing unusual about this ruling. It's not like, oh my goodness, all the courts are doing something different here than they do everywhere. What's happening? This is commonplace.
Welcome to the American criminal jurisprudence system.
And the life of a criminal defense attorney.
Yes, and appellate attorneys and innocence projects and all those who advocate for people that they believe are wrongfully convicted and incarcerated. It's a very, very, very difficult task to accomplish in terms of getting things undone. We say it constantly on our podcast, and we say it because it's true. It is so hard to undo things. And you cannot, in terms of cases that have eyes on it, like that are still kind of going, I don't know that there's a case that has more eyes on it than Stephen Avery. And these judges are aware of that, but they've got a job to do, and they're, and they've obviously formed opinions. I mean, if you had one of these 3 that was like, wow, I'm kind of buying it. I can't get over the fact that Stephen Avery was about to get, a few $1,000,000 and he's got a film crew following him around, that he's such a savage animal that he couldn't control himself and just decides to kill Teresa Halbach. Like after he's called her to the house and everyone knows that she's going to be there. It seems strange to me. It seems like he's a real animal. I don't know. It's like this case. It's another one that drives me nuts. So finally, Avery argues the circuit court made a variety of factual errors in its written decision that are unsupported by the record. We have already addressed some of these purported errors. Other examples include that the court referred to Bobby as Brian at one point in its decision, stated Brendan was forensically linked to the crime, stated Halbach's bones were found in Avery's burn barrel. Her electronics are found there. Her burns were found in multiple locations, including Avery's burn pit, and stated bone fragments from almost every bone in the human body were found in the burn pit. This statement, however, was proven at trial by the forensic anthropologist who found at least one fragment from nearly every bone in the human body within the burn pit. We have reviewed the purported errors and conclude they have no bearing on the circuit court's denial of Avery's post-conviction motion. By the court, order affirmed. End. Finite.
And there you have it.
There you go. So, I mean, going into it, now you would have the opportunity to read Kathleen's post-conviction relief act petition. Like leading into this, where were you leaning? What did you think might happen?
I mean, I thought that they met the standard to the Denny standard with the new evidence. That was my opinion. Whether I thought it out to its logical conclusion of what will the court do with it, I don't know. But I think that there was enough there.
Yeah,
Court
because
gets briefed.
remember, we're not talking about a remand. We're not talking about Stephen Avery gets a new trial. We're talking about an evidentiary hearing where we could put these people that provided affidavits on the stand, where theoretically you can call Bobby Dassey to the stand. All right, babe, you can go. So, all right, y'all. Obviously, like I said, this opinion is in no way going to affect our evaluation of the case. I think I saw in the chat that Zellner is already on record that she's going to appeal it to the Supreme Court. I fully anticipate the Supreme Court's going to come down the exact same way that the Appellate Court did. They're going to have to get it out of Wisconsin, is my feeling on this. And, but on the federal court side, it's not easy there either. Like, it's just a very difficult process. This is one of those things where if Avery's ever to get out based on him getting a new trial and they go through the process and he's acquitted, he's going to be an old man, because these things just take forever. And you've got nobody on the other side, meaning the government side, that is willing to say anything even remotely close to, we think we might have gotten the wrong guy here. Like nobody, like, we all know Kratz is a douchebag, but notwithstanding that, there's just nobody on that side. There's nobody that's looked at the case after Kratz has been gone. Nobody, which is not unusual. Again, that is par for the course. It is very, very rare for a subsequent prosecutor to come in, or two prosecutors ago or three prosecutors ago to come in and undo their colleagues' work. It's very, very rare. Rarely ever happens. So we'll see how it plays out. But and it's funny that this came down, because Allie and I have been doing our prep work for getting the second season of Avery recorded and out to y'all. And again, I just want to restate that this is not changing any of that. We're still moving forward. The case is still very much active. And frankly, I sat here, I asked Allison, I was not surprised. Like I said, I'm always surprised when the thing that rarely ever happens. That's when I'm surprised. I'm never surprised when the thing that almost always happens. So, I'm just of the mindset that it's another bump in the road. These are certainly, but every level of the system that is rejecting your theory makes it that much harder to convince the level above it, if that makes sense. So at this point, we have the trial court, now the appellate court, dismissing these theories of Zellner and Stephen Avery. And so now you've got to have, even though they're only going to look at the appellate court, the reality, they can't pretend that the trial court hasn't weighed in on this, because it has, and now the appellate court has. So when the Supreme Court of Wisconsin looks at it, they're going to know. So it's tough. It's tough for those of you out there that are adamant that Stephen's innocent. Keep up the fight. Because you guys at this point, at least, because we're still going through the evidence, probably have a greater understanding of the evidence. You won't after we're done with our podcast. We'll have equal footing in terms of the evidence, but don't give up. That's the point. You can never give up. If you've got a firm belief in something, you got to just keep your head down, keep plugging away, and just hope that others that have the ability to fight for him are willing to do it as well. So, that's that. And if you're on the other side of it, if you think Avery's as guilty as the day is long, well, you had a good day today, you know. Because you attach Zellner's name to it, it gives it credence. She's won enough of these to where when she involves herself, um, oh, thanks, Kraken. We appreciate that. We appreciate that. Like I've got no agenda here other than to try to educate you guys on what the reality is, and I love our country. I love our system, our judicial system. I think it's flawed as hell, but I think that the bones are there for a good system. I just think that there's a lot of warts, and the question becomes how do we cure those warts so that we have a better system? I mean, as much as I hate AI, at some point when you're like, is the one thing that AI is never going to do is it's never going to use emotion in its application of logic and the law. I mean, that concept scares the shit out of me. But a lot of times, like, it is impossible for people to separate emotion from their analysis. Like, it's just in there. And then they like, I'm not at all sweating anybody on that. Like, I am an emotional person. Like, emotional is how I operate. And it is exceptionally difficult to put that aside when you're dealing with these types of cases, when there was, loss of life and devastated families. And, it's really, really hard to do. So I'm not at all sweating people on that because it's human nature. If you're like an actual human being that's got empathy, which I think most of us do. So, um, you know, we'll see what happens next in this. But I can guarantee you in the interim that our second season of Avery will be dropping, and I'm excited for that. So tomorrow, I a case that I am following, that Allie and I are going to be following very heavily, is Corey Richins. There's a lot of action that happened yesterday. There was quite a few things that were filed. Um, I think there's an interlocutory appeal going on over there. So tomorrow we're going to do a Corey Richins live. I'll give you folks out there that are not familiar with that case a little bit of a primer at the beginning of that one. It's another crazy case. Like, just to kind of tempt you with it, it's instead of a husband killing a wife, this is a wife alleged to have killed her husband by giving him a fatal dose of fentanyl, and money being the motive. And that maybe this will ring a bell. After she's alleged to have killed him, she then writes a children's book to help her children get over the grief of their father dying. So it's a crazy case. It's out there out west in Utah, where it just seems like there's something in the water out there between Idaho and Utah. A lot of crazy stuff goes on out there in the Wild West, but we think it's an interesting case. We think that you guys will think it's interesting as well. So hopefully you'll join us. Hopefully Mandy will get my thumbnail. I want to start trying to get these things promoted a little earlier. I know that we're kind of late a lot of times, but we're trying to get better. I'm getting things scheduled ahead of time as I promised with my to my mods with my this thing. I had no choice in scheduling it. I just found out yesterday, as the rest of the world did, that the opinion was going to be dropping today. So I couldn't have planned this. This is one of those things that couldn't have been planned ahead of time because it just popped up. So that's one of those. But as far as, oh, and another major announcement, my second interview with Brad Rosie, Allie and I will be having him on Tuesday of next week, not Monday, because one of our beautiful subs, one of our beautiful humans pointed out to me, hey, Bob, remember when Brad had to leave early the last time he was on because Notre Dame was playing? Monday night is when the national championship game is playing. So thank you. I wish I could remember which sub it was. It was somebody either on my Twitter or here that let me know. So that will be Tuesday evening, 7 p.m. Eastern Standard, 6 Central Standard Time. I will give you guys plenty of notice for that second part of that interview with Brad Rosie. We think that it will be interesting. So you guys, let me thank those. Susie Q, new member. Kale, it's my favorite time. It's your favorite time. It's my favorite time. It's what's a direct appeal time. No doubt. Thank you for your generosity. Laura, thank you for being a member for 9 months. It's been a while. It's good to see everyone. Nice to see everyone. Welcome back. Welcome back. We've missed you. Roxanne Hurst, new member. Appreciate you. Thank you very much. Gladiator. Saw you real active in the chat. We're so happy you're here. Thank you for becoming a member, Gladiator 1422. We appreciate it. Kenny Powers. Have they ever investigated Avery Supdoc? Funny. That's good. And then I love Allie. Bob is simply the best. I agree, Kenny. I could not agree more with that proposition. Thank you so much for your generosity and welcome. We love having you in the chat. And Kenny Powers, in my estimation, is one of the funniest characters that was ever made for TV. Absolutely love that show. I love everything that he's in because he's just hilarious to me. And then finally, I can see Dan was back in here. I'm always glad that Dan's here. I know Dan got timed out. He voiced his opinion on him being like Dan's a contrarian. I mean, he tells us right in his name. So like I enjoy Dan's company. Dan's always welcome here. So don't like I think my mods tended to take his kind of sarcastic contrarianness like the wrong way. I find him to be delightful. And like I've said a million times, you are allowed to disagree with me. And I'm here for the debate. I'm here for it. Like good luck convincing me on shit though. I'm hard to convince otherwise. As most people are. Like once we're all dug into a position, we're dug in. So thank you so much for your generosity, Kenny. We really appreciate it. And thank you guys so much for hanging with us this morning. Please, I'm begging you. I am begging you. Please make sure you like on the way out. We want to get this content. Like the way that the algorithm works is that YouTube decides who they're going to show what content to. I watch a lot of other content. There's a lot of great content out there. I think ours is just as good and better than most. And we need your help getting it out there. That's why I'm always begging you guys. That's why we're always talking about sharing is huge. Liking is huge. Commenting is huge. Subscribing is huge. Like just to get us out there. I think we're close to crossing 37,000, which is great. Great. But we want to build this community. And like the one thing that I love is this community that we've built. I love it. You guys are amazing. And I want to share you guys with the world. I have never seen anybody that's come into this chat, except for maybe Dan. And that's because the mods booted him. That has ever said, man, that community sucks. Like everybody that comes into this community, and you guys know, and we're watching trials and we have new people come in, they're like, this community is amazing. They're hilarious. They're smart. They're thoughtful. They're kind. Like you guys are, obviously I'm biased, but I love you guys. You guys are amazing. You make this a joy to do. You really do. You really make this just an absolute joy. It's hard. I love you guys so much that I have to turn off the chat. Like if I'm doing an interview where I want to focus, because I just love what you guys have to say. Like I read your chats, all of them. If I'm turning it off, I go back and I watch because what you guys say and think matters to me. And I couldn't love you guys more. So with that, I bid you a fond farewell. I hope that you all have a wonderful day. And I look forward to seeing you tomorrow. Wait, Dan, are you the same Dan? Is Kenny Powers contrarian Dan? Oh, see, I love that. You guys and like that shows how much I love Dan that he had the brilliance to use Kenny Powers as his alter ego. Free, I agree. Free Dan. I'm freeing Dan. Like I asked, I didn't see anything that was so offensive that Dan should have been booted. You know, I mean, Dan's just a smartass and a contrarian. Like, I love that. So, all right, you guys are amazing. I love you all. We will see you tomorrow. Remember, Corey Richins. Remember, like, share, subscribe. If you're on replay, please put something in the chat, even if it's just replay. It gets it out there. It gets it out there. And we want to get it out there. All right, we love y'all. Ciao.